Electricity Act 2003 for Kerala PSC exam, departmental exam, in-service exams, PSC exams, UPSC exams, UGC NET exam, degree PG level exams and various other exams. Section 3. Section 3 envisages that the central government from time to time prepare the national electricity policy, including the tariff policy, in consultation with the state governments and the authority for development of the power system based on optimal utilization of resources, including conservation thereof and the use of renewable sources of electricity, and publish the same. Section 4. Section 4 envisages that the central government shall, after consultation with the state governments, prepare and notify a national policy permitting standalone systems, including those based on renewable source of energy and other non-conventional source of energy for rural areas. Section 5. Section 5 envisages that the central government shall also formulate a national policy in consultation with the state governments and the state electricity regulatory commissions for rural electrification and for bulk purchase of power and management of local distribution in rural areas through users associations, cooperative societies, non-governmental organizations, franchises or panchayat institutions. Section 7. Section 7 inter alia provides that any generating company may establish, operate and maintain a generating station without a license under proposed legislation if it complies with the technical standards relating to grid connectivity. Section 8. Section 8 envisages that any company intending to set up a hydroelectric generating station shall obtain approval of the appropriate government. Section 9. Section 9 envisages that notwithstanding anything contained in proposed legislation, a person may construct, maintain or operate a captive generating plant and dedicated transmission lines provided that the supply of electricity from such a captive generation plant through the grid shall be regulated in the same manner as the generating station of a company. Section 10. Section 10 provides for the duties of generating companies such as to establish, operate and maintain generating stations, tie lines, substations and dedicated transmission lines connected therewith in accordance with the provisions of proposed legislation or rules or regulations made thereunder. Section 11. Section 11 provides that the appropriate government may specify in extraordinary circumstances that a generating company shall operate any generating station in accordance with the direction of that government. Section 12. Section 12 provides that no person can transmit or distribute or undertake trading in electricity unless he is authorized so to do by a license issued under Section 14 or exempted under Section 13 of the Act. Section 13. Section 13 provides that the appropriate commission, on the recommendation of the appropriate government and also in public interest, direct, subject to such conditions and restrictions, by notification that any of the provisions of the proposed legislation shall not apply to any local authority, panchayat institution, users, association, cooperative societies, non-governmental organization. Section 14. Section 14 provides for grant of license by the appropriate commission to transmit, distribute and undertake trading in electricity in any area specified in the license. Section 15. Section 15 provides for the manner of application by a person seeking license and the procedure for grant of license by the appropriate commission. Section 16. Section 16 provides for every licensee to comply with certain conditions as specified therein. However, the appropriate commission shall within 1 year from the appointed date specify any general specific condition of license to be applicable to the deemed licensees after the expiration of period of 1 year from the commencement of the proposed legislation. Then Section 17. Section 17 imposes certain restrictions on the licensees. It provides that a licensee shall not, without the prior approval of the appropriate commission, undertake any transaction to acquire by purchase or take over or otherwise merge his utility with the utility of any other licensee in the same state. It also provides that any agreement relating to any transaction specified above shall be void unless the same is made without prior approval of the appropriate commission. Section 18. Section 18 provides that the appropriate commission on an application by the licensee or otherwise make such alterations and amendments in the terms and conditions of a license in the public interest. Section 19. Section 19 provides for the circumstances under which the appropriate commission may revoke the license. No license shall be revoked unless the appropriate commission has given to the licensee not less than 3 months notice in writing stating the ground on which it proposes to revoke the license and has also considered the cause shown by the licensee against the proposed revocation. Section 20. Section 20 provides that where the appropriate commission under Section 19 has revoked the license of a licensee, the appropriate commission may invite application for acquiring the utilities of the licensee. Section 21. Section 21 provides that where a utility is sold under Section 20, the utility shall vest in the purchaser, free from all encumbrances such as debt, mortgages, or similar obligations of the licensee, and the purchaser shall be deemed to be the licensee, exercising all the powers under the license. Section 22. Section 22 provides that if the utility has not been sold in the manner provided under Section 20, the licensee may dispose of the utility in such manner as he may think fit. Section 23. Section 23 provides that the appropriate commission may give direction to the licensees if it is necessary and expedient so to do for maintaining the efficient supply and securing the equitable distribution of electricity and promoting competition. It may also be order provide for regulating supply, distribution, consumption or use thereof. Section 24. Section 24 provides that if at any time in the opinion of the appropriate commission, a distribution licensee has not complied with the terms and conditions of license and any direction given by the appropriate commission specified therein, the appropriate commission for reason to be recorded in writing suspend the license for a period not exceeding 1 year and appoint an administrator to discharge functions of the distribution licensee in accordance with the terms and conditions of license. The appropriate commission shall give reasonable opportunity to a distribution licensee before suspending a license. The period of 1 year of suspension, the license shall be either revoked and utility sold in accordance with the procedure laid down in Section 20 or restored to the distribution licensee. Section 25. Section 25 provides that the central government may make region-wise demarcation of the country for efficient, economical and integrated transmission and supply of electricity to facilitate interconnection and coordination of facilities for the interstate, regional and inter-regional generation and transmission of electricity. Section 26. Section 26 provides that the central government may establish at the national level a national load dispatch center for optimum scheduling and dispatch of electricity among regional load dispatch centers. Section 27. Section 27 provides that the central government shall establish a center for each region to be known as the regional load dispatch center having territorial jurisdiction as determined by the central government and shall be operated by a government company or any authority or corporation established or constituted by or under any central act as may be notified by the central government. Section 28. Section 28 provides for the functions of the regional load dispatch center as the apex body to ensure integrated operation of the power system in the concerned regions. The regional load dispatch center shall be responsible for coordinating the regulation and control of land optimum scheduling and dispatch of electricity within the region in accordance with the contracts entered into with the licensees or the generating companies operating in the regions. It also provides that the center shall comply with such principles, guidelines, and methodologies in respect of wheeling and optimum scheduling and dispatch of electricity as specified by the Central Commission in the Grid Code. The center shall further be responsible for carrying out real-time operations for grid control, etc., in accordance with the grid standards. The center shall monitor grid operations, keep accounts of the quantity of electricity transmitted through the regional grid, and exercise supervision and control over the interstate transmission system. The center may levy and collect such a fee and charges from the generating companies or transmission utilities or licensees engaged in interstate transmission of electricity as may be specified by the Central Commission. Section 29. Section 29 provides for compliance by every licensee, generating company, generating stations, substations, and any person connected with the operation of the power system of the directions given by the regional load dispatch center for ensuring stability of grid operations and for achieving the maximum economy and efficiency in the operation of the power system in the region under its control. Section 30. Section 30 provides that the State Commission shall facilitate and promote transmission, wheeling, and interconnection arrangements within its state territorial jurisdiction for the transmission and supply of electricity by economical and efficient utilization of the electricity. Section 31. Section 31 provides that the state government shall establish a center to be known as State Load Dispatch Center. It also provides that a government company or any authority or corporation established or constituted by or under any state act to be specified by the state government shall operate the State Load Dispatch Center. It further provides that until such government company or authority or corporation is notified by the state government, the state transmission utility shall operate the State Load Dispatch Center. Further, such state load dispatch center shall not engage in the business of trading in electricity. Section 32. Section 32 provides for the functions of the State Load Dispatch Center as the apex body to ensure integrated operation of the power system in a state. The State Load Dispatch Center shall be responsible for optimum scheduling and dispatch of electricity within the state. The center shall be responsible for carrying out real-time operations for grid control and dispatch of electricity within the state in accordance with the grid standards and the state grid code. The center shall monitor grid operations, keep accounts of the quantity of electricity transmitted through the state grid, and exercise supervision and control over the intrastate transmission system. The center may levy and collect such fee and charges from the licensees engaged in intrastate transmission of electricity as may be specified by the State Commission. Section 33. Section 33 provides that the direction of the State Load Dispatch Center shall be complied with by every licensee, generating company, generating station, substation, and any other person connected with the operation of the power system for ensuring grid operations and for achieving the maximum economy, efficiency in the operation of the power system in the state. If any dispute arises with reference to the quality of the electricity and safe, secure, and integrated operation of the regional grid or in relation to any direction given, it shall be referred to be State Commission. Section 34. Section 34 provides that every transmission licensee shall comply with such technical standards of operation and maintenance of transmission lines in grid standards as may be specified by the authority. Section 35. Section 35 provides that the appropriate commission may, on an application by a licensee, by order require any other licensee owning or operating intervening transmission facilities to provide the use of such facilities to the extent of surplus capacity available with such licensee. Section 36. Section 36 provides that the compliance of the order made under Section 35, the licensee shall provide his transmission facilities at rates, charges, and terms and conditions as may be mutually agreed upon. Section 37. Section 37 provides that the appropriate government may issue directions to the regional load dispatch center or the state load dispatch center to take such necessary measures for maintaining the transmission and supply of electricity to any region or state. Section 38. Section 38 provides that the central government may notify any government company as the central transmission utility. However, the central transmission utility shall not engage in the business of trading in electricity. The central government may transfer and vest any property, interest in property, rights and liabilities, and personnel involved in the transmission of electricity to a company or companies to be incorporated under the Companies Act 1956 to function as a transmission licensee. The functions of the central transmission utility shall be, inter alia, to discharge all functions of planning and coordination relating to interstate transmission system, to ensure development of efficient, coordinated and economical system or interstate transmission lines, and to provide non-discriminatory open access to its transmission system on payment of transmission charges and a surcharge thereon as may be specified by the Central Commission. Such surcharge shall be utilized to meet current level of cross subsidy, and that such surcharge shall be progressively reduced and eliminated. Section 39. Section 39 provides the state government may specify by notification any board or government company as the state transmission utility. However, the state transmission utility shall not engage in the business of trading in electricity. However, the state transmission utility shall not engage in the business of trading in electricity. The state government may transfer and vest any property, interest, property rights and liabilities, and personnel involved in the transmission of electricity to a company or companies to function as transmission licensee. The functions of the state transmission utility shall be, inter alia, to discharge all functions of planning and coordination relating to interstate transmission system, to ensure development of efficient, coordinated and economical system of interstate transmission lines, and to provide non-discriminatory open access to its transmission system on payment of transmission charge and the surcharge thereon as may be specified by the State Commission. Such surcharge shall be utilized to meet current level of cross subsidy, and that such surcharge shall be progressively reduced and eliminated. Section 40. Section 40 provides for duties of a transmission licensee to build, maintain and operate an efficient and coordinated and economical inter and intrastate transmission system, and also to provide non-discriminatory open access to its transmission system on payment of transmission charge and a surcharge as may be specified by the appropriate commission. Such surcharge shall be utilized to meet current level of cross subsidy, and that such surcharge shall be progressively reduced and eliminated. Section 41. Section 41 provides that a transmission licensee may engage in any business for optimum utilization of its assets. Section 42. Section 42 provides for the duty of a distribution licensee to develop and maintain an efficient, coordinated and economical distribution system in his area of supply. It also provides that where any person whose premises are situated within the area of supply of a distribution licensee requires a supply of electricity from a generating company on any licensee other than such a distribution licensee, such a person may be notice require the such a person may by notice require the distribution licensee for wheeling such electricity in accordance with the regulations made by the State Commission, and the duties of such distribution licensee in respect of such supply shall be those of a common carrier providing non-discriminatory open access to its distribution system. Section 43. Section 43 provides for supply of electricity to be given to the owner or occupier of premises by a distribution licensee within 1 month or within 6 months where such supply requires extension of distribution means commissioning of new substations. If a distribution licensee fails to supply electricity within the period of specified above, he shall be liable for a penalty which may extend to 1000 rupees for each day of default. Section 44. Section 44 provides for certain exceptions from duty to supply electricity as required under Section 43 if the distribution licensee is prevented from doing so by circumstances beyond his control or by cyclone, floods or storms or other occurrences beyond his control. Section 45. Section 45 empowers the distribution licensee to recover charges for supply of electricity in accordance with the tariffs fixed from time to time and conditions of his license. Section 46. Section 46 empowers the distribution licensee to charge from a person requiring supply of electricity any expenses reasonably incurred in providing any electric line or electric plant used for the purpose of giving that supply. Section 47. Section 47 empowers the distribution licensee to seek reasonable security from any person who requires supply of electricity subject to certain conditions specified therein. The security amount so given by the person requiring a supply of electricity shall be refundable and carry interest equivalent to bank rate or more as may be specified by the concerned State Commission. However, a distribution licensee shall not be entitled to any security if any person requiring supply is prepared to take through a prepayment meter. Section 48. Section 48 imposes certain additional terms of supply requiring any person who seeks supply of electricity to accept, subject to certain conditions referred to therein. Section 49. Section 49 provides that where the appropriate commission has allowed open access to certain consumers under Section 42, such consumers may enter into agreement with any person for supply or purchase of electricity. Section 50. Section 50 provides that the State Commission shall specify an electricity supply code to provide for, inter alia, recovery of charges, disconnection for non-payment, tampering of electric lines or meters, etc. Section 51. Section 51 provides that a distribution licensee may, with prior intimation to the concerned the State Commission, engage in any business for optimum utilization of its assets. Section 52. Section 52 provides that the appropriate commission may specify the technical requirement, capital adequacy requirement and creditworthiness for being an electricity trader. Section 53. Section 53 provides that the authority may specify suitable measures by regulations relating to safety and electricity supply suitable for the purposes, inter alia, of protecting the public including persons engaged in the generation, transmission, trading, or use of electricity, eliminating or reducing the risk of personal injury, giving notice in the specified form to the appropriate commission and the electrical inspector of accidents and failure of supply or transmission of electricity. Section 54. Section 54 provides that no person other than Central Transmission Utility, State Transmission Utility, a licensee shall transmit or use electricity at a rate exceeding 250 watts and 100 volts in any street or in any place in which 100 or more persons are likely ordinarily to be assembled, or which is a factory or a mine, etc., without giving not less than 7 days notice to the electricity inspector and to the district magistrate or the commissioner of police, as the case may be. Section 55. Section 55 provides that no electricity shall be supplied to any person after the expiry of 2 years from the appointed date, except through a meter to be installed and operated in accordance with the regulations to be made in his behalf by the authority. Section 55. Section 55 provides that no electricity shall be supplied to any person after the expiry of 2 years from the appointed date, except through a meter to be installed and operated in accordance with the regulations to be made in this behalf by the authority. Further, a consumer who requires electricity may be required by the licensee. Further, a consumer who requires electricity may be required by the licensee to give security for the price of a meter and enter into an agreement with the licensee for the hire thereof, unless the consumer elects to purchase a meter. Further, the State Commission is empowered to extend the period of 2 years by notification for a class or classes of persons or for such area as may be specified in the notification. If a person violates any of the conditions specified in this section, the appropriate commission may make an order requiring the default to be made good. Section 56. Section 56 provides that in case a person neglects to pay any sum due from him to a licensee or a generating company in respect of supply, transmission, distribution, or wheeling of electricity, the licensee or the generating company shall be empowered to disconnect such supply after giving a notice of 15 days. However, the supply of the electricity shall not be cut off if such person deposits the amount equal to the sum claimed under protest or as security pending disposal of the dispute. This section also provides that no sum due from any person under this section shall be recoverable after a period of 2 years from the date when such sum became first due, unless the same has been shown continuously as recoverable as arrears of charges for electricity supplied. Section 57. Section 57 provides that the appropriate commission may, after consultation with licensees and persons likely to be affected, make regulations regarding standards of performance of a licensee or a class of licensees. It also provides that if a licensee fails to meet a specified standard, it shall pay compensation to the person affected by such failure. Such compensation shall be payable within 90 days from the date of determination by the appropriate commission. Section 58. Section 58 provides that the appropriate commission may specify different standards for a class or classes of licenses as specified in subsection 1 of section 57. Section 59. Section 59 provides that every licensee shall furnish to the appropriate commission information as regards to the number of causes of payment of compensation under section 57 and level of performance achieved under that clause. It also provides that the appropriate commission shall at least once in every year arrange for the publication of such information furnished to it. Section 60. Section 60 provides provides that the appropriate commission may issue direction to a licensee or a generating company in case such licensee or generating company enters into any agreement or abuses its dominant position or enters into a combination which is likely to cause or causes an adverse effect on competition. Section 61. Section 61 empowers the appropriate commission to specify by regulation the terms and conditions for the determination of the tariff, and in so doing the commission shall be guided by inter alia the principles and methodologies specified by the Central Commission for determination of tariff for generating companies and transmission licenses, commercial principles for conducting the generation, transmission, distribution and supply of electricity, principles regarding efficiency or performance, multi-year tariff principles, progressive reduction and elimination of cross subsidies, the national electricity policy, etc. Section 62. Section 62 provides that the appropriate commission shall determine the tariff for supply of electricity by a generating company to a distribution licensee. However, in case of an agreement between a generating company and a licensee or between licensees for a period not exceeding 1 year, the appropriate commission may fix only the minimum and maximum ceiling of tariff. The appropriate commission shall also determine the tariff for transmission, wheeling and retail sale of electricity. The appropriate commission shall not show undue preference to any consumer of electricity while determining the tariff. Further, the tariff or any part thereof shall not be amended ordinarily more frequently than once in any financial year. The appropriate commission may require a generating company or a licensee to comply with such a procedure as may be specified for calculating the expected revenue from the tariff and charges. However, if the generating company or any licensee recovers an excess amount from the consumer, the same shall be recoverable by the person who has paid such excess amount along with the interest equivalent to the bank rates. Section 63. Section 63 provides that notwithstanding anything contained in Section 62, the appropriate commission may adopt the tariff determined through process of bidding. Section 64. Section 64 provides for the procedure to be determined by the appropriate commission in respect of tariff order. It provides that every applicant who seeks determination of tariff under Section 62 shall file an application along with the requisite fees and publish the same into 2 leading newspapers circulating in India. The appropriate commission shall publish a draft tariff order inviting suggestions and objection. The appropriate commission shall within 120 days from the date of receipt of application either issue a tariff order or reject the same for reasons to be recorded in writing. A copy of the aforesaid order shall be sent to appropriate government, the authority and the concerned licensee by the appropriate commission within 7 days of making the order. This section also provides that a tariff order shall continue to be in force for the specified period unless amended or revoked. Thank you.